Good afternoon, Dobr den. I am Brunella Carriero, the scientific coordinator of the project. I welcome you today at the fifth seminar, Succession and Family Law in Practice, that is held via streaming today and tomorrow, 1 day and a half. You know, the project EU Law in English is funded by European Commission DG Justice and Consumers under the Justice Programme. The project is led by a consortium consisting of Fondazione Italiana del Notariato, Cassa Nazionale Italiana del Notariato, the International Association of Judges, the Bulgarian and Hungarian Chambers of Notaries. This afternoon, we have the privilege of hearing the TOT experts. Elena Ioriatti, she is a full professor in comparative private law at Trento University Faculty of Law. She'll speak about the legal language of the EU, first part, with an explanation of the practical game. Then Daniele Muritano, he is a civil law notary in Empoli, Florence. He is also member of the Commission for Civil Law Studies within the Consiglio Nazionale del Notariato Italiano. He'll speak about general consideration of the 3 European regulations and focus on public order and also practical cases. Then Charlotte Oliver, she is a solicitor of England and Wales, Avvocato in Italy. She'll speak about legal English in practice and remarks on the Italian Supreme Court number 1820. Tomorrow, we'll have the honor of hearing 2 notaries and 2 judges who are trained of the Train of Trainers course, that is TOT, held in Rome last year. They are now the trainers in this 5th seminar. They are Thomas Malnar, he is a Hungarian notary trainer. He'll speak about 3 practical cases on the habitual residence as new connecting factor within the 3 regulations. Then Agnes Buxi, she is a judge trainer in Hungary, and she'll speak about 3 practical cases on the choice of law to be presented and discussed with reference of the 3 regulations. Then Teresa Battista, she is a civil notary in Italy, and she'll speak about the succession regulation before the European Court of Justice. Then Sara Maffei, she is a judge in Italy, and she'll speak about rules of jurisdiction within the 3 regulations. There will be time also for questions and answers. And in the afternoon, tomorrow, we'll hear again Daniele Muritano and Charlotte Oliver for a discussion time on previously communicated practical cases and feedback provided by the trainers, and then Professor Elena Ioriatti. Daniele Muritano will present all e-learning products of our Emma MOOC. The approach of this seminar will be more practical than theoretical. Our experts and trainers will dedicate time to discuss practical cases, and their manner will be informal. Now I have the honor to leave the floor to the representative of the Bulgarian Chamber of Notaries, Ivaylo Ivanov, civil law notary in the district of Sofia. Ivo,
hi everyone.
all of us are in Sofia now.
Yes, you're welcome.
We are breathed the scent of Bulgarian roses. And after the seminar, you know, we'll walk together, of course, with a distance between us, around your wonderful Vitosha Boulevard, right, Ivaylo? So, well, enjoy our seminar. Thank you for your attention. Благодаря.
Thank you, Brunella. Thank you. I'm so pleased to see you all online. Unfortunately, as you all know, the seminar has to take place in Sofia. So we are, the Bulgarian Notary Chamber is the host of the seminar. And but okay, we have prepared a very special program for the dinner, and after that for the night and the day after the seminar, but we have to postpone it for the next year probably. As we know, so many plans God loves. So what I'm very happy about is that the seminar, however, takes place even online. And thank you very much to the Fondazione Notariato, and especially to Alessandra and to Claudia and to Brunella, to all of you, that you didn't give up and you find a way to continue with the seminar. I'm sure it will be very interesting. I don't know how you succeed to keep all people for 1.5 days before the computers, but let's try. I participated in many of these seminars and they're really, really very interesting. And doing it online has let's say, good sites, like if you want to do something that has not to be seen, you can just stop the video or to mute. You have to be muted all the time, and to do it for 1 second and after that to continue. And so enjoy the seminar. Thank you very much, all of you. Have a nice and interesting day. See you. Bye-bye. Thank you.
Please, Elena. Thank you.
Thank you. Good afternoon to you all. I'm Professor Elena Ioriatti, and as always, I'm very, very glad to be here and to join this very interesting seminar. And I would like to start by thanking once more Brunella Carriero for inviting me, and the Chamber of Notaries of Italy and Bulgarian and Hungary too, of course. And also thank you very much from the bottom of my heart to Alessandra and Claudia, who have really helped me a lot to prepare this presentation. So just a few words to explain to the people who never met me before what I do in life. I am professor of comparative law at Trento University in Italy. This means that I teach comparative law, and particularly I teach comparative legal systems in English. And then I also teach a small course, a workshop on EU legal language and legal translation. And I teach with course together with some linguists. So we share many languages. We teach in English, Italian, French, and German, and that is very stimulating. And in my field of research, I deal with the law and language of the European Union, and particularly I do research on a model that I will talk about it tomorrow, about how the legal language of the EU could be interpreted and applied uniformly in Europe. And I must say that also from my point of view, this cooperation, all these seminars, and we are now at the 5th seminar, have been very, very interesting, and I learned a lot. And this is why today and tomorrow I will also focus on the cooperation that we build it up together, also with notaries and the judges of Bulgaria and Hungary. I would like to start with, next slide, please, by saying that before starting the seminar, I went through the history of Bulgaria a little bit that I found very, really very interesting and stimulating from my point of view. I learned, for example, that Bulgaria got autonomy for the first time in 1878 by the San Stefan Treaty. And in the same year, we had this Berlin Treaty that also favored the autonomy of Bulgaria. And then after the revolt of 6 September 1885, Bulgaria reached the unification. And after that, on the 22nd September 1908, the complete independence from the Ottoman Empire. From my point of view, these are the moments in which Bulgaria became, from the point of view of comparative law, a legal system. So it means body of rules regulating well-defined social groups, so in this case, a state, rules which could be enforced. And so at the beginning of the 20th century in Bulgaria began what we call, what we denominate as comparative law scholars, a model circulation. I would like to switch for a moment to the second slide and then come back to this one. Could you please go to the next slide? Okay, thank you. What do we mean with model in comparative law? For us, model is whatever could be imitated. So an institute like the trust, for example, or a specific concept, so specific legal words, or a case law decision, so a judgment, a ruling something new. Like in Italy, we have what we call in Italian the danno biologico, that I can only translate it literally like biological damage. I don't know whether it is a correct translation, but it's a very new, it used to be a very new institute in Italy, elaborated by case law. So models could also be elaborated by the judges and also by notaries by finding a new solution, a new praxis. Doctrinal opinion, so the opinion that we all have, and during this seminar, we always seriously joke by saying that our doctrinal opinion are the one of Daniele Muritano, who is an expert in this regulation. So it is our expert on the regulation. And also the entire legal system in theory could be imitated. It could be considered as a models. So what happened in Bulgaria? Could I come back to the previous slide, please? No, the previous one, it's a slide number 2. Yes, thank you very much. If we look at Bulgaria from above, like a legal system, we see that in the 20th century, we had some new legislation enacted on persons, property, contract, and successions. And all these regulations were based on the Italian model. So we had the model circulation from Italy. And this is very interesting. And as we will see, we will share some solution with regard to the word possession, for example. Then with regard to commercial law, we had the circulation of the Hungarian model. But the Hungarian model was based on the German model. So we have this overlapping of solution in Bulgaria. And again, we will see that there is an interesting situation with regard to the word possession because of this overlapping of models. In civil procedure, Bulgaria imitated the Russian model at that time. And so we have this very interesting mixture that we as comparative law scholars, we observe as a sort of puzzle, as we will see in a while. Okay, next slide. So again, if you look at Bulgaria from the point of view of the models, you see all the different paces that some of them are original, as we will see, and some of them are imported. Okay, next slide, please. With regard to model, all the legal system of the world, as we will see, might be composed by different models. And in comparative law, we use the word original models when we refer to an institute, a concept, a word that is created specifically in one legal system. For example, the trust. Daniele Muritano has already told a lot, explained a lot about the trust during this seminar. I don't know whether it will be picked up again, but very quickly, the trust is a very, very typical instrument of the English legal system. It was invented there, and for this region, it is denominated an original model. And it is composed by three parts: the one who created the trust, the setter of the trust, the trustee, and the beneficiary. And it is a very interesting institute that we all know, but it is typical of England. Then equity. I think that Charlotte Olivier will explain to you what equity is, but very briefly, equity is a part of the English legal system that was created in the 15th century by the chancellor, who was the person in charge, a religious man at that time, a person in charge of the chancery that was a part of the Curia Regis of the court at that time. And equity develops some remedies like the trust itself, or remedies like undue influence, the discovery order, or very typical remedies that now are integrated into the English legal system, but that were based on these specific procedures that it was regulated not by the law, but by moral, by the religious rules. Another example is the very famous Rechtsgeschäft, that is a German model. It is a category that we do have in Italy, and I suppose that you have in Bulgaria, because we share this model on the contract and obligation. That is a category that is more general than the contract, and that in Italy was translated into negozio giuridico. So the original models then circulated in other legal systems. For example, we see the trust that was imitated in the United States and then in Canada. And what is interesting is that when the trust circulated into the Canadian legal system, it changed in part its denomination, because in English it was still denominated trust, while in the French versions, because there is a part of Canada, the Quebec, that is bilingual, in the French version it is called fiducie. So it picked up a French denomination, but it is still the same institute with two names. Then the Rechtsgeschäft circulated in Italy, and it's denominated negozio giuridico. You have probably noted that I haven't said anything about equity, because equity did not circulate in the United States, or they did it just in a very typical situation, because the problem was that equity in England was a process carried on from a procedural point of view without the jury. It was there was only one judge, the chancellor. And you probably know that in the United States, the jury is very important in the process. It's considered a sort of sign of democracy. And so because of this reason, the equity did not circulate that much in the United States. So this is the way that we use in comparative law to observe the legal system. So if you go to the next slide now, we see that the composition of the legal system, it might be from a certain point of view original, in the sense that in England, for example, we still have the trust and the equity remedies, but very, very often, or quite always, a legal system is not composed by original models, but, next slide, please, it is the outcome of a huge circulation of models. So all our legal systems are composed by pieces of different other legal systems. And this, as we will see in a while, give rise to a very interesting game. Because as a comparative law professor, but even if you're a jurist, if you are curious, for example, and you enter into the legal system, you discover a wonderful world of words, institute, terms that are borrowed from one another legal system, then they are changed, then they are reborrowed to another legal system. It's a very, very interesting world. Next slide, please. So you see, here I put a slide, and I have printed this image on the reverse on purpose, because you see the word is upside down. And I did it on purpose because I just wanted to show you that the model circulation goes in one direction, but also in the other direction. So for example, France, that is a very prestigious legal system, which has imported a lot, is now re-importing models that were originally, they were French model, that they circulated in another legal system, and they were imported again with some changes and different shapes. Next slide, please. So when a model circulate, I mean, it is imitated or even imposed, because if you think, for example, about the period of the colonization, all the many European models were imposed in Africa. So when a model is imitated or circulated in comparative law, we say that we got a legal transplant. But a legal transplant, it is something that does not belong to a legal system, that is imported or even imposed. So in this case, we might have different problems. We might have a problem of legal translation. So how do we translate a model when we imported it in our legal system? And you may say, okay, but when we just translated the language, because when we imitated the Italian model, we just used the Bulgarian words, so where's the problem? But then in a while, we will see that legal translation is not so simple in reality. And the same is with the compatibility of the models. Because, as it happens in medicine, sometimes a model could be simply rejected by the legal system. And this is again very interesting. I have an example for you. If you think, for example, about the European arrest warrant, that is a simplified cross-border judicial surrender procedure for the purpose of executing a custodial decision or a detention order. This is a European model that was imported in all the European legal system. this European arrest warrant has replaced the extradition procedure in theory, because the extradition procedure, it's very lengthy, probably takes time, while the European arrest warrant is supposed to be more rapid. What did happen in Italy? In Italy, we of course imported this European model, but because of the bureaucratic system of Italy, it didn't work. So, I mean, it lost its precious aspect of being very rapid. So in Italy, we went back to the extradition. And this is an example of rejection. So legal transplant could be accepted, but it could also be rejected. Like I'd say, like it happens in medicine, that something that has been put it into my body is rejected. It doesn't work. It doesn't fit into the rest of the legal system in the case of the legal model. I try to explain all this through a serious game. And it's really pity that we cannot play the game together today, because for example, in Budapest and in Rome, we had a lot of fun with this game, but I will try to explain to you. So I need the next slide, please. So in this game, we normally play with this color block you have already seen in the previous slide. And we had different players. So we organized the group in a small group of 3 players. We have, for example, player A and player B. And I asked the player to sit back to each other. And I put in front of them a series of wooden pieces of different shapes and colors. So could you please go for a while to the next slide and then come back? Okay, these are the different pieces that I put in front of the player. So now we could return to the previous slide, thank you. So none of the 3 players has a chance to see what the other 2 are doing. So player A is asked to create a construction with the wooden pieces. And why he or she builds up, for every time he or she moves pieces, this must be communicated in English to the other player. But they cannot see each other. They can only listen to what we call the translator, that is player C, communicate. So player C transfers the same information in English, and the player B has to do exactly the same movement and to do the same thing. In the end, player B is asked to create identical construction with the pieces. And so when we play this game, we always say to the player, then at the end, we will compare the building, and the more similar ones will win the game. But the point is that, could we go to the next slide? Okay, so you see the wooden, okay, perfect. The problem is that in the end, the constructions are not identical at all, because what the player don't know, because we do not tell them before they start the game, what they don't know is that not all the pieces are identical. So if you see this construction, they are similar, but they are not identical. Next slide. Because some pieces had the same shape, but different colors. If you see here, the shape is the same, but the colors are not. Next slide. Then we had pieces with the same color, but different shapes. And then, next slide, we have pieces with different shapes and also different colors. That was the most complicated situation. What all this means in terms of comparative law, and then of course all this situation correspond to a reality. So let's go to the next slide and see that in comparative law, the color represents the language in which a legal concept is expressed. So simply the legal word we use to communicate the institute. While the shape represents how a legal concept is composed. And so let's go to the next slide where there is an example. As I said, the color represents the language. So if you look at the word divorce in the USA and the word divorzio in Italy, before the reform of 2015, the language is very similar, divorce, divorzio, but the content of the two institutes was very different. Because the divorce was very fast, a very rapid procedure in the United States, while in Italy, in order to get a divorce, a divorzio, we had to go through the separation. That means that the two spouses had to live separated for a number of years. But then, after the reform of 2015, we did introduce this marriage dissolutions, and that is very similar now to the American divorzio, because we do not need this period of separation anymore, but the language is different. So you see in the first example, you have the two legal languages that are very different, but the content of the rules and the norms and the institute was different. In the second example, the languages are different, but the content and the rules are very similar. So then we can move to the next example that is more related to European law. I will start with the Bulgarian model. And here I would like to thank very much Natalia Nedelcheva for helping me a lot to build up this example and this slide, and also to Mrs. Pamela Valkova of the Notary Chamber of Bulgaria. And I had all the information from them, and particularly for Natalia. So, as I said, Bulgarian imitated an Italian model. And so I would like to work on the word possession, that in Italian is possessors, we will see. In Bulgaria, this is regulated by the Ownership Act. There was an act that, if I remember well, in the 50s, and when updated and updated, and the last updated is February 2020. And in Article 68, we have this word, vladenie, and this possession is an exercise de facto power over a property which the possessor holds as his own. So it means that in Bulgaria, like in Italy, in order to be a possessor, you need the animus domini. It means that you have to possess as an owner. Then in Bulgaria, you have this other institute that is darzane, in English holding. That means that exercising a de facto power, but not holding with animus domini. It means I hold a thing, a good, a property, but I do not act as an owner. I know that I have to return this good to the owner, but of course you know this aspect better than me. So could we move to the other slide? In Italy, we have more or less the same situation. We have possesso and detenzione. So possession with animus domini and detenzione that without animus domini. So next slide. We have this situation also in the Switzerland legal system, because in part of Switzerland, the language is Italian. But what is interesting, that is the word possesso, the Italian one, and Switzerland means de facto power over a thing in general. So it includes both the possession and holding. So here you see that even at the European level, we have this distinction between the language and the content of a legal institute, because in this case, we have a word, possesso, in Italy, that means one thing, that there is another legal system which does not belong to the European Union, but just to show you that the language may include different institutes, that means something very different. Okay, next slide. And then, if we go back to the European Union, we see that this difference is existing in Austria and Germany as well. Because in Austria, we have Besitz, this opposed to Innehabung. And then in Germany and Switzerland, this Besitz means de facto power in general. So again, we have the same difference that we have into the Italian legal language. The difficulties that we have illegal transplant, and this is what could we go to the next slide? So the difficulty that a jurist encounter in legal translation is that legal concept cannot be translated literally from one language to another by simply rely on the word of the ordinary language. And then most of the time concept and words do not coincide. So this is why we always try to explain to the participant to this seminar by means of a very serious game. Because if you remember the game, the player were convinced to have exactly the same pieces in their hands, so the same color and the same shape. And so when they found each other to transfer one model, to move the pieces in order to imitate the other construction, and they realized that the pieces were not the same, they had to find a solution. They had to be creative. And sometimes they, by instinct, they went for the language, so they chose the color. And this means that if you transfer this model into the reality, it means that when you imitate a model from another legal system, you just choose the word. And it is exactly the situation that some legal system did with the trust. France, for example, has been trying to imitate the trust for years. And initially, the trust in France was denominated fiducie, because France realized that the institute was very different. But then, with the passing of time, also France and also Italy and other legal systems tried to imitate the trust, and in order to spread the message that that was really the English trust, for example, in legal literature, we started to use the word trust. But the result that we had the same institute as England, I mean the same name, but the rules were not the same, because of course I don't want to venture into an area that is not my expertise, because Daniele Muritano knows a lot about it. But if I'm not wrong, the Italian trust is not exactly the English trust. I mean, there are still differences in the two institutes. Then if we go back to our game, we see that sometimes the player went for the shape. So they said, okay, I don't find the right color, but I have something very similar. So they choose a block that had the same color but a different shape. So in this case, it means importing into the legal system an institute, a norm that it's exactly the same as the one that was present in the original legal system, but using different words. And this is exactly what happens, for example, in Canada. You remember the example of the trust, where the trust, this is exactly the English trust, but in French, it is denominated fiducie. So fiducie like the French fiducie. So we have these differences into the different legal system. And for today, I would like just you to mentally focus on the fact that what you see in the legal system might not be exactly what was imported from Italy or Germany or Russia, because the rules are a bit different, or it might be exactly the same, even if the word is not the same. And this is typical of the model circulation. And then tomorrow, we will see that this difference between the content and the language in the different model is very important with regard to the European legal institute. So the institute and the model that are somehow imposed on the legal system from the European Union. Not because the European Union is imposing anything to us, because being member of the European Union, of course, it is a privilege, it is our choice, and it is very positive, at least from my point of view. But however, when a directive or a regulation is enacted, in the legal system, we find ourselves as a jurist to handle new words, new institute, new rules. And so we have to find out solutions for that. And then tomorrow we will see how the comparative law methodology will apply in this situation. So let's remain in the national legal system for today, and let's pick up a very, very simple example that is so simple that it seems naive, but behind this there is an entire world of differences. Think, for example, of the word contrat in France, or simple contract in England, or contratto in Italy, or vertrag in Germany. Of course, nowadays at the international level, we do use the word contract when we translate the Italian contratto, but this is the level of international English. And this is another point that is quite interesting. And for this reason, you're very lucky to have Charlotte Olivier in this project. Because Charlotte, she really can explain the legal language of England. That is not the legal language of the European Union, and it is not the legal language of the international, let's say, legal environment. This project is denominated EU Law in English, and it was a very, very clever idea. I know that this project was, the idea was that of Brunella Carriero, and she was also supported by Alessandra, and that was a very, very clever idea, because we all know that English is getting a lingua franca at the European level, but at the same time, we do not have only one legal English, as it was with French, because when French was informally, the unique language of the European Union, because the very first treaty were negotiated in French, and French was the language was the point of reference for interpretation, there was one legal French. It was the French of France. And in fact, we had a sort of model circulation of French models into the structure of the European Union. But nowadays, things are very different. And what we say English, we always have to think a lot of what we mean with English. We have the ordinary natural language, that is the language spoken in England, that is of course different from the one that is spoken in the United States, but now we are still focusing on Europe. Then we have the legal English, and we have the legal English of England, of the common law, and Charlotte will explain to you, and it will be very interesting, and how the legal English of England was created. And then we have the legal English of the international environment. That is a very flexible language, and it is the lingua franca, used to be French in the past. And there we can translate contratto with contract, and with contrat. So no one will be surprised to hear that. But if you move into the language of the member state, you cannot compare the word contratto with the one simple contract, because we have huge differences. And here you can experience the difference between the legal language of Italian translated into English. For example, the Italian contratto is, of course, a bilateral instrument, and it includes what in Italian we would denominate the donazione, so the donation, the gift. Because in Italian legal language, donazione is bilateral in the sense that the one receiving the donation, the gift, has to accept. So the donazione is a contract in Italy. But if we move to England, the simple contract is at the same time a bilateral agreement, but it did not comprehend the gift and the donation, because the donation is an act under seal or deed. So in England, it is not part of the same category, it is not a contract. So strictly speaking, in legal translation, we have different levels. We have, again, the level of the international English, then we have the level of the legal English of England, and then tomorrow we will see we have the legal English of the European Union. That is an even more complicated issue because the European Union is creating a new legal system with a new legal language, with new words, as we will see tomorrow. And so this is another level. So again, legal English has different aspects. And I think that this project was built up and organized in a very interesting and clever way, because it gave us the possibility to explain all this level of the legal language. Okay, so could we go to the next slide? So we have been playing this serious game several times in the project. And so now we have a sort of experience, and we could share some data together. I think that, first of all, I put the word culture there in the slide, because at the very beginning, when we experienced this game, we were, and particularly I was, very hesitant. I was not sure whether this game would have fit into this project. And I remember that I experienced it for the very first time in Rome. And again, I had to thank Brunella and Alessandra, because they encouraged me to start the seminar with this game. And I think that being so hesitant is a point of culture, because as Italian, and particularly as an Italian professor, we normally teach in a very traditional way, by explain, by asking question to, in my case, a student. And we do not often experience new methodological tools, like a game, for example. But in this game, I think that it was an occasion for me to break my personal Italian culture. And so we started with this game, and I must say that for the very beginning, it was very interesting, and I think it was also funny somehow. And so I think that we somehow put aside cultural barriers by playing this game. What I also noticed is that there was a difference between the participant having a previous background in comparative law, of course. We had some people involved who were educated in Trento, in my faculty, so they were trained in comparative law, so they immediately pick up the meaning of the game. But at the same time, I think that also the participants who have never heard anything about comparative law, after a first moment they were probably at the very beginning disoriented, but that they immediately enter into the game, and they started to realize by intuition what was going on. And this was very important for me as well, for my research, because what I try to do, and I will explain to you tomorrow more in depth, I try to follow the reality by explaining it through the methodology of comparative law. And so also for me, it was very important to learn that by intuition, someone who never heard anything about comparative law went in the right direction. The profession, honestly, but of course, I also would like to hear the opinion of the participant and also of the Brunella, Daniele, and Charlotte. I haven't noticed any difference between the reaction of notaries and judges. So they all play the game with enthusiasm, and they also ask very, very interesting and clever questions at the end of the game. And of course, this was not because of me, but because of they were really involved and seriously took seriously the game and the situation. They immediately understood the basis of comparative law thanks to the game. And for this reason, I also would like to thank you all, I mean the professionals who were already involved, because I had very good reaction, very interesting question. And as I will explain to you tomorrow, this is really helping me to build up my own research. And for this reason, I would like to end up this part of the presentation by focusing on collaboration. I really, thanks to the game and thanks to this, to being a member of this seminar and of this project, I really think that we are building up a network. And I have experienced it as a scholar, as I said already, when I ask for some support from some, I ask question, I need data for my research, I had a very immediately and enthusiastic reaction. So I think that is really an added value of this project, and we will see tomorrow how all this collaboration is proceeding, and I think is growing day by day. Then the role, this is a very important point. I haven't noticed any difference in this project between the expertise, or so the people who were supposed to be there to teach, or professional who was supposed to be there to learn. In a few seminars, we were all at the same level, and we learn, and we learn from one another, and we exchange information. And I think that we are building up what is really a fruitful collaboration, also from my point of view. I mean, as I said, what I study is the European legal language, and I am convinced that the European legal language is very important in the interpretation and application of EU law. And this is, that it needs a stronger collaboration among the jurists in Europe. And this is what we are really building up. As I will explain to you tomorrow, I had increased the level of my research thanks to this project and to all the exchange of information we have. Next slide, please. So this was the first part of my presentation, and it was only just to give you some basic information on the comparative law, on the models, on the language, and on how a legal institute is composed. And then tomorrow we will apply all this information to the European Union. And so we will go more close to the legal instruments that are the object of this workshop. And I really apologize today for having based my presentation on different aspects of the law, but we need to build up the background. So we need the bricks to build up our educational building. So tomorrow we will proceed with the legal system of the European Union. We will observe the European Union as a legal system, and we will try to understand how to approach the legal language in a sort of neutral way. And I will explain to you also how my research is carried on. That as I said, it is a research that is also, I hope one day, will be useful to the jurists and particularly judges and notaries in Europe. So thank you very much for your attention. And we will go on tomorrow with the topic of the legal language of the European Union.
Thank you, Claudia. I want to highlight that among us there is Antonio Areniello. He is the president of the Fondazione Italiana del Notariato, Notary in Naples, and a member of the board of directors of the National Council of Notaries in Italy. He prefers not to interrupt our works, but he sends us his greetings and his congratulations for the seminar. Thank you, Antonio, for your attention and your participation. Well, the floor now to Daniele.
Thank you, Brunella. Thank you, everyone. This is a new experience for our seminars online due to the virus. And I will start with a presentation divided in two. The first part is dedicated to an overview of the three regulations, because our project is focused to the examination of the three regulations, mainly the succession regulation, and briefly the other two regulation. So there are the regulation about property, matrimonial property regime, and the property consequences of the registered partnership. In the second part, I will address the relationship between the regulation on successions and public policy. I would like to, if it's possible, can I share my screen, my own screen, please? Okay. So, sorry. Here are the succession regulation number 650 of 2012. And what's the reason of this regulation? The problems that led to the approval of the regulation is that each member state of the European Union have completely different private international rules for succession. For example, some member states use domicile, but with a different definition from the usual common law ones. Others use the nationality criterion, and this is more less confused than the domicile or habitual residence. But the different criteria provided for by the individual private international rules can lead to contrast and to uncertainty into the determination of the applicable law. This is the reason because the regulation has been approved, not of course to harmonize the substantive rules of succession, that is quite impossible, but just to harmonize the private international law rules of the member states. Of course, the regulation was approved in 2012, but entered in force on August 17 of 2015. So the regulation is applicable to the succession, as we can see here. It shall apply from 17th of August to 2015. So for persons died on or after this date. So this is important because for persons died before, each private international law rules of each state will apply. The regulation is composed by 84 articles. So in this overview, I do not examine all the articles because there are other speakers that will go in depth to the different aspects of the regulation. I will do only an overview. But very important is that the regulation has also the so-called recitals. The recitals are 83. So we know that the recitals are not bound because they are not dispositions, but recitals. Okay. But they are very important for the interpretation of the disposition of the regulation. There are lots of these recitals that are very important. For example, the recitals about the use of criterion to determine the habitual residence, for example, or other recitals on, for example, disposition on forced heirship, the certificate of succession, and so on. The regulation does not bound every member state because, as you know, there are some states that opted out from the regulation, and these states are United Kingdom, Ireland, and Denmark. So this is important because the regulation bound only the member states, but the interpretation of this expression member state means that the member state is a state that is bound by the regulation. So even if, for example, United Kingdom now is still a member state, is not a member state for the purposes of the regulation, because the regulation will apply only to the participants, so only to the member states that are bound by the regulation. So for the purposes of the regulation, the United Kingdom must be considered as third state, and this is important for the application of the disposition on the remoi provided for in Article 34. So the regulation aims to define a unique criterion to determine the applicable law to the succession. And the nullity of the regulation is that it harmonizes the private international law rules provided for to determine the applicable law, introducing a sole criterion valid for all the member states that is different from the domicile, habitual residence, or nationality that was used in the various member states. And in fact, we can see that in Article 21, the regulation provide as a general rule, the habitual residence rule. So the main criterion to determine the applicable law to the succession is the habitual residence. But before going into an explanation, a brief explanation of these, it's important also to expose the structure of the regulation, because the regulation is divided in 7 chapters, each one governing a topic of in matter of succession. The first one, it's very, very important because the first chapter covers scope and definitions, scope of the regulation, and very important definitions in Article 3. Chapter 2 deals with jurisdiction, which is given to the state of the last habitual residence. Chapter 3 relates to applicable law, which is to be that of the state of the last habitual residence, but with the provision for the testator to choose the law of nationality, so the professio juris. The remoi that is governed by chapter 3 is partially abolished. We can apply the remoi in some situations. The chapter also deals with question as to capacity to make the disposition of property upon death, and validity of wills and succession agreements. Chapter 4 deals with recognition and foreseeability and enforcement. Chapter 5 regards authentic instruments and court settlements. And very, very important, chapter 6 concerns the European Certificate of Succession, that is the main innovation of the succession regulation. The provision of this new document, whose nature is at the moment not clear, even if the Court of Justice just ruled about the certificate, the European Certificate of Succession, but this is a very, very new provisions, because it's a document like this was not provided in any of European Union regulation. It's important to know that the regulation, of course, is drafted in the various languages of the member states of the European Union, but each language has the same the same meaning. So the problem of language is also an important one, because in some member states a term may have a meaning, and in another member states the same term may have a different meaning. Of course, the interpretation of all the provisions of the regulation and all of the terms of the regulation shall be an autonomous interpretation, as the European Court of Justice stated in the various decisions that it issued in these years. In the succession regulation, we know the European Court of Justice just issued, I think, 6 or 7 decisions that are very important, and in each one of these decisions, the European Court of Justice clarified and confirmed that the interpretation of the single terms of the regulation must be an autonomous interpretation. For example, the term residence is not an internal one, but is an European term. The same for the meaning of the term succession, and so on, property. So, so this is important, of course, because the interpretation of a regulation must be coherent with the different member states. It's not possible to think that, for example, the term residence have a meaning in Italy and a different meaning in France or Germany. The term of residence must have the same meaning in all of the member states participating or bound by the regulation. It's very important to understand the relationship between Article 1, that is about the scope of the regulation, Article 2, 3, and 23, because the regulation apply to succession to the states of the deceased person. So if we are not dealing with a succession, the regulation not apply at all, of course. In fact, we have a lot of material that are outside the scope of the regulation, and they are listed here in the Article 1, paragraph 2. These are all issues that are topics that are excluded by the from the application by the regulation. But it's very, very important to note this letter G, because this is a I think a sort of a kind of partial exclusion, because even if the regulation does not apply to property rights, interests, and assets created or transferred otherwise than by succession, and here there are some examples, gifts, joint ownership, and so on, it's important to note that the article point I of Article 23, paragraph 2 is safe, is applicable. So if, for example, a donation violates a forced heirship provision, the applicable law to the succession will allow the disgruntled heir to attack the donation with the action of reduction, as we know, for example, in Italy. This is very important, this provision, because some think that if we use a device provided by another state, so if it's an inter-virus device, is not affected by the regulation. This is not true. This is not true, in my opinion, because the regulation say in a clear way that the exclusion is made without prejudice to point I of Article 23, paragraph 2. If we read this article, let I, we can see that the heir can restore, determining the shares of the different beneficiaries. So this is governed by the applicable law to the succession, not to the inter vivos instrument used by the deceased. This is a very important piece. For example, many scholars say state that, for example, as the creation, administration, and dissolution of trust is excluded by the scope of the regulation, using a trust may frustrate the interests of the legitimate heirs, the legitimate expectations of heirs. It's not true, because even if here the regulation does not recall Article 23, paragraph 2, it's true that a trust is a device that allow people to transfer rights, property rights, interests, and assets otherwise than by succession. This is true. And so, if if we're using a trust, an heir is disgruntled, he or she may attack the trust. Then we can see here another aim of the regulation. Another aim of the regulation is not completely reached, in my opinion, is that of the principle of the unity of succession. We can see this in the first recitals of the regulation. The aim of the regulation is to allow the court to apply his own law, and we can see here, we can see this this purpose of the regulation here in Article 4, that deals with the general jurisdiction. The rule is that the courts of the member state in which the deceased had his habitual residence at the time of death shall have jurisdiction to rule on the succession as a whole. As the main criterion is that of the habitual residence, we can see that the court, in this case, will apply its own law. And this is a principle of unity, of course. One law is applicable to the succession, and there is also an aim to the coincidence between forum and use. The use of the law applicable is the same of the forum. Of course, there are possibilities to change the court. Of course, but we can see this afterwards. I think there are other speakers that will address this topic of the regulation. But the main criterion is this one. So the court will apply its own law to the succession, and of course, the succession will cover all the aspects of the succession. So it's not possible that a succession to be governed by different laws. One law is applicable. In Article 21, we can see this here. The general rule in Article 21 is that the law is applicable to the succession as a whole. So the whole of succession, the entire succession, will be governed by one single law. And other important characteristic of the regulation is that the applicable law is that the regulations, the regulation has universal application. So the law applicable to the succession may also be the law of a third state, because it's important, the habitual residence. And so here in Article 20, we can say that any law specified by the regulation shall be applied whether or not it's the law of a member state. So, for example, if the habitual residence is in China, we will apply the Chinese succession law. Here we can just jump to the disposition about the renvoi, because in the regulation there is an important clarification about this this issue, because when the regulation lead to the law of a third state, it's important not to stop to the substantive law, but to examine the private international disposition of that state, because it's a third state and not a member state. In the case of China, for example, we have not to stop to the Chinese law, but we have to check what the private international law of China provide for where a succession is international. In fact, Article 23 clarifies that when the application of the law in a third state mean the application of the rules of law enforced in that state, including its rules of private international law. So we have to check what the private international law of that state provide and verify if there is a renvoi to another law. In this case, it's Article 34 that that reads that the renvoi is accepted in specific cases if it's the law of a member state or the law of another third state, which would apply its own law. And another example, another example may be common law countries. Common law countries, as you know, provide for the decision system of the applicable law to the succession. So these states will apply the law of this domicile to the movables, and the lex recite, lex situs for the immovables. So in this case, for example, if the deceased is a habitual residence in London, for example, but have an immovable in Italy, for example, in this case, we have to check the private international law of the United Kingdom and the private international law of the United Kingdom provide that the succession of immovables is governed by the lex recite. So in this case, the United Kingdom law makes renvoi to the law of the third another state, and as this state is a member state like Italy, these states have must accept the renvoi. So in this case, we have we won't have one applicable law, but two laws. One law for the movables and one law for the movables. So in this is one of the cases where the principle of unity of succession is not reached by the regulation. And there are, of course, other provisions depending on the states of the habitual residence, if this state is a third state. So it's very complicated, the Article 34. I don't know if in the workshop, I think we will examine the problems about renvoi with also Charlotte, that she will explain how it works in England. It's very, very important. Another important provision is Article 22. If I have already said that there is a sort of correction of the general criterion, because even if the general criterion of the regulation is that of the habitual residence, we have a sort of a correction in Article 22, because in Article 22 the regulation provides for the state or for a person to choose the law that will govern his or her succession, and this law may be the law only the law of the nationality. So, for example, an Italian resident, habitual residence in Germany, can choose Italian law to govern his succession. It's very important, because within the aims of the regulation, there is also the predictability of the law applicable to the succession, and each one can observe that the criterion of habitual residence is not a certain criterion, because the habitual residence may change, of course, and so when the habitual residence change also the applicable law. So, for example, if there is a will, of course, the law applicable will change if the person that made the will change his or her habitual residence. The possibility to choose the law of nationality give us certainty to the applicable law, because once the choice of law is made, is not changeable unless the person will change his or her nationality. So if I'm an Italian resident, habitual resident in Germany, and I make a will choosing Italian law, of course, even if I at the time of death will be residence in France, the applicable law to my succession will be Italian law, because I've chosen Italian law, so the law of nationality. And there's another important consequence of the choice of law, because in Article 34 about renvoi, provide an exception to the application of the renvoi. In fact, the paragraph 2 of Article 34 provides that no renvoi shall apply with respect to the laws referred to in article, in particular 22. So the law of the nationality. And this is obvious, of course, because otherwise we wouldn't have certainty of the applicable law. So, for example, if the deceased had his or her habitual residence in the United Kingdom and made a will choosing Italian law, the renvoi would not apply. So the whole succession will be governed by Italian law. There are other important provisions here that we will address briefly. In Article 35 provide the exclusion of the application of a provision of the law, but I will address in depth this matter afterwards. There are other provisions important to determine the applicable law when states have more than one legal system, because, for example, think to Spain of United States that are federal states. United States is a federal state, is not a U.S. applicable law, but each U.S. state is applicable law. So in this case, we have to check, in this case, if there are conflict of law rules. Otherwise, is Article 36 that provide a criterion. It is not very useful to apply as connecting factors because it is the criterion of the close connection. It is not easy to apply the close connection. Other important provisions are those about the certificate of succession. We will address this during the seminar. I just said something about this. Is a very important innovation of the regulation, introduced by the regulation, and the purpose of the certificate is to facilitate to handle the succession, where the succession, of course, is international, because, of course, one of the apply is international, is a cross-border succession. Otherwise, of course, the succession will be internal, and so the succession regulation will not apply. Let's see some other things. Oh, I think that we can stop here about this and say something else about the other two regulations, because we have also two other regulations involved in our seminars. That they are the regulation 1103 and 1104. These two regulations are very important because until these two regulations didn't enter in force, the problem of the succession was influenced by the rules of matrimonial property regime. And now are affected because these two regulations, in particular, the regulation 1103 is applicable only to couple married on or after the 29th of January 2019. So for couples married before, there is an interference between the succession regulation and the internal rules, private international rules, and substantial rules on matrimonial property regime. So when we have to handle a cross-border succession, we have to take in account also these rules, especially verifying if these are succession rules or matrimonial rules, because if are succession rules, the regulation will apply. If they are not succession rules but matrimonial rules, the regulation won't apply. So these are the interferences may lead to contrast from the point of view of the person that deal with the succession, because each state, each member state, or in general, each state has internal rules to determining, for example, if there is a separation of property or community of property. And from the point of view of the person that handle with succession, the conclusion to for what regards the ownership of a specific property may lead to different conclusions, because in some states, for example, in Italy, we have the community of property of a matrimonial property regime of default in absence of a different choice by the couple. In other, for example, in United Kingdom, there is no matrimonial property regime. In other, there is the separation of property or has a default regime. So we have also to check this interplay between the succession regulation and the matrimonial property regime regulation. And we will see in the workshop one case where this problem is might be addressed and must be addressed, because the conclusion may be different depending on the date of the wedding. If the wedding is prior to 29 of January 2019 or after 29 of January 2019. The regulation 1103 and 1104 are called also the twins regulation, because they are formally they provide the same rules, just to determine the applicable law, the choice of law, are the same. But of course, in the 1104, we have to deal with couples that are not married but registered partnership. So there are some slightly different rules for this couple, but the skeleton of the two regulations is the same, and they have been drafted using the succession regulation as a template, a sort of template, because of the chapters, the provision are very, very similar between these two, the twins regulation and the succession regulation, because we have rules about the jurisdiction, rules about applicable law, rules about the choice of law, recognition of judgments, and so on. So this a difference between the succession regulation and the twins regulation is that the twins regulation have been approved in the within the judicial cooperation. So the judicial cooperation is used by the European Commission when there is not possible to reach unanimity between the member states. So these two regulations bound only the participant states that are 18. So there is another problem, because within these 18 states participating to the judicial cooperation, we will apply succession regulation and the twins regulation. But the member states that didn't participate to these two regulations, we will apply the internal private international rules. So we have a sort of a further interplay between succession regulation, private international law rules about matrimonial property regimes, and the twins regulation. So it's a very, very complicated situation to deal. Of course, we will wait also the decision of European Court of Justice to clarify how this interplay works. This is the first part. I will now move to the public order, because this is very important, for example, especially from the point of view of states like Italy, that provide for disposition that protect the legitimate expectation of the close family members of the family. This is so it's a very important problem, because just a moment. Why is important to speak about public policy? Because there is, of course, as I said before, a specific disposition in the regulation, that is Article 35, that provide that the applicable law to the law applicable to the succession is possible not to apply when is against the public order.
I'm sorry, Daniele, we saw the presentation view at the moment,
okay.
Not the presentation in full screen.
This one, okay?
Okay,
yeah.
It's okay. Thank you.
So in this case, and the problem is that in some states consider the internal provision about the forced heirship as public policy. So we have to see if, for example, especially from the Italian Italian perspective, if the internal disposition on forced heirship are part of the international public policy, because this is the problem. So this is the main disposition, and this is the so-called public policy clause. Public policy is also referred to in a recital, so in the recital 58, which calls on the member states to respect the Charter of Fundamental Rights of the European Union, in particular Article 21 thereof, which prohibits all forms of discrimination. But we have, before going into details on the identification of the concept of international public policy, also from the Italian perspective, it needs to clarify the distinction between the public policy and necessary implementing rules. Public policy, in fact, is defined in general as the set of principles that identify the legal system at a given moment in history. The necessary implementing rules, on the other hand, are rules that must always be applied as an expression of principles or requirements having a practical nature. They prevent the recall of foreign rules. For example, in Italy, we have internal rules that prevent the circulation of immovables that are not compliant with the building rules. These are not public policy, but necessary implementing rules. Article 35 refers only to international public policy and doesn't cover cases of fraud against the law. Fraud against the law can be always objected, and in fact, if we read the result 26, the result 26 provides that it is not a disposition but a result, but the clarification is that the regulation does not prevent the single member state to use the evasion of law to object to a disposition of property upon that. When can the public policy exception be raised? There are two preconditions. Of course, the case must be cross-border, and a foreign law has to be applied in another member state, for example, in Italy, and the case conflicts with fundamental principles of the legal system. And we have to clarify that the fundamental principles of the legal system operate, first of all, as a limit to private autonomy, and therefore determine the invalidity of the acts that might violate them. So in this case, we will speak of violation of domestic public policy. In private international law is different. It's not limited to the party autonomy. The fundamental principles are an impediment as to the production of legal effects, both by foreign laws and by foreign decision. And this is the international public policy and presuppose, as I said before, a cross-border situation. So if we can summarize the results of scholars and the case law, we can state that domestic public policy includes the fundamental principles or identifying provisions of the Italian Republic that can be derogated either in domestic or foreign cases. International public policy includes mandatory principles or rules that are in compliance with the Constitution, but not the expression of fundamental principles. So they are derogable from a foreign law. It's important, this one, to clarify that the international public policy is not an European concept, because it's the responsibility of each state to identify the content of international policy. However, the Court of Justice monitors the application of the provisions on public policy laid down in European legislation. I put into this in the slide two cases decided by the European Court of Justice. But under Article 35, the application of a provision of law of any state may be refused only if such application is manifestly incompatible with the public policy. So the provision of Article 35 must be interpreted restrictively because it constitutes an exception to the general rule. Manifestly reads the Article 35. So the use of this adverb indicates that the public policy clause must be, as I said, interpreted restrictively. Moreover, a wide application of the clause would contradict one of the objectives of the regulation, namely the predictability of the applicable law, and would jeopardize the beneficial effect of Article 22, which allows the choice of law applicable to this accession. In exceptional cases, of course, it will be possible to disapply specific provisions of foreign law because of the conflict with the public policy clause. For example, a state may invoke the application of the public policy clause if the applicable law is discriminatory. Basically, this happens when the law discriminates on the basis of religion or sex, or provides, for example, that a person must convert, embracing a particular religion in order to be heir. For example, under Sharia law, the attribution of the inheritance depends on the religion of the deceased. As a general rule, non-Muslims are excluded from inheritance. However, the use of public policy clause to disapply foreign inheritance law should not be theoretical, but we have to consider the material case, because the same rule of law can be contrary to public policy depending on the circumstances of the case. In particular, cases of hypothetical discrimination must be carefully assessed, because in some legal system, for example, women have fewer inheritance rights than men, but on the other hand, these fewer rights are counterbalanced by other benefits. That depends not on they are not a real discrimination, but a different style of family organization, for example. And this may happen in Muslims country, for example. In any case, it remains firm that the assessment will have to be made on the basis of international public policy that is not European concept, as I said, but derives from the values of each state, which are, of course, variable. And that the importance of that of this, so that the values to be taken into consideration, has been stated in various decisions by Italian Supreme Court. In particular, the first one is of 2016, where the Supreme Court refers to shared values under stated by European Court of Human Rights and European Court of Justice case law. So this shows that the concept is not just internal. This is internal, but we have to refer to supranational values, of course. Sorry. Another clarification has been made by this judgment in 2017, and here the Supreme Court refers to constitution and legal traditions with a different differences constitute a limitation. So also in this case, the Italian Supreme Court accepted a decision coming from the United States in the field of punitive damages, recognizing the judgment because not contrary to public policy. Again, sorry, in these other two judgment, this one of 2019, of course not 2019, also in this case, the Italian Supreme Court dealt with the problem of recognizing of foreign decisions, applying, of course, the assessing of the compliance, not only looking at the fundamental principle of our constitution, but also to the international and supranational sources. So sources in terms not only of charts, but also case law. Case law handled by issued by European Court of Justice and European Court of Human Rights. So let's move to the relationship between international public policy and foreign laws that not contain provisions reserving inheritance shares. So this is the case where the applicable law, of course, does not provide any right for the specific person, and so the problem is if the heirs may attack this position. Before the 17th of August 2015, a person may choose as law applicable to their succession the law of the state of their residence. In this case, there was a limitation, so the choice of law of residence was ineffective if at the time of death the person was no more resident in that state. But the rights of Italian forced heirs were protected by the Italian law by the same Article 46, because the choice of law did not compromise the forced heir rights if the heirs are resident in Italy at the time of death of that person. Some scholars consider these rules contrary to the Italian constitution because they seem to discriminate between Italian citizens residing abroad and those residing in Italy. And they constituted, on the other hand, an obstacle to the free movement of persons, because persons residing abroad were bound by the rules of the protection of forced heirs in succession planning. These were the rules before. Now we have different rules after 17th of August 2015, and in the succession regulation there are not many references to the forced heirs position, just in these two articles, 13 and 23, letter H, 29 and 77. And of course, there are different rules between the different member states, and the law applicable will be the law of the habitual residence. There are references to forced heirship rules in the recitals of the succession regulation that are relevant for the interpretation. Here, for example, in recital 38 reads that the choice of law was provided for to avoid a law being chosen with the intention of frustrating the legitimate expectation of persons entitled to a reserved share. So in this case, for example, an Italian nation may choose only Italian law and not law of the habitual residence, of course. So choosing the Italian law, the legitimate expectation of the close member of his or her family will be protected. But of course, this is not enough, because if a person is habitual residence in a state that not provide protection of forced heirs, this is not important for the regulation. That law will apply unless the heirs would prove an evasion of law, the fraud à la loi, as recitals 26 provides. Another reference is in recital 50 that defines what is the reserved shares, or maybe also another right of which a person cannot be deprived by the person whose estate is involved. So this is important. Another notation I can do about the nationality, because we have seen that the Article 22 provided the choice of the law of nationality, but it's possible that a person have multiple nationality. So if a person have a nationality of a state that provide forced heirship provisions and of a state that not provide the forced heirship provision, he or she may choose one of these two laws, because the succession regulation does not provide the effectiveness of the nationality. So if I can choose the law of a nationality of a state with which I do not have more connection at all, and in this way I can frustrate the forced heirs, the heirs, because the law of that state does not provide anything for the close member of family. And this is a possibility for a person if he or she has multiple nationality and was to exclude a specific member of family. It's enough to choose the law of the state that does not provide protection for forced heirs. So the problem here is, if of course is a problem also for other states, Hungary, Bulgaria, and so on, if the Italian forced heirs protections are not public policy rules. We have a first ruling, but the Italian Supreme Court in the 1996 that stated that the forced heirship provision are not part of public policy. So from an Italian point of view, may be possible to violate these provisions. Another ruling was in 2014. Also in this ruling, the Italian Supreme Court stated that the Constitution does not protect the provision of law regarding forced heirship. So in that case, the disgruntled heir was not allowed to contest, to challenge the will. And it's very important. By the way, the assessment must be done in concreto. So this is justified by the story of the forced heirship provision, because in the Roman law, the forced heirship provision were connected with the needs of a person. Now they are not connected with the needs of a person. A person have his share independently of his financial needs, for example. But if there is a will, for example, excluding an heir, and this heir is in a specific financial situation, so it's needs something to live, for example, probably it's possible to challenge a will because of these economic difficulties or state of need of the heir. So the assessment must be done in concreto. For example, this criterion was applied by French Supreme Court in 3 cases where the French Supreme Court stated that forced heirship provisions in French law are not part of public policy, but on the other hand, stated that the assessment must be done in concreto. So if a person is in state of need, probably also in France, it would be possible to challenge a will excluding a close member of the family by the inheritance. It's also another problem to verify if are relevant the remedies available to the excluded person. For example, in see this practical case, an English citizen having assets in Italy drafts a will, chooses English law, and excludes his son. English law also applies to the succession of the property in Italy, because we know that when a person makes a choice of law, the removal is not applicable. But we know that in England, the child may, within 6 months, under the Inheritance Act 1975, challenge the testamentary provisions and obtain an inheritance right. In this case, is this sufficient to exclude a breach of public policy? I don't know. We can discuss about this. Maybe in this case, the person has an option to exercise. If he does not exert this option, is his or her problem. But the provision is not for this reason void, not contrary to public policy. Also, agreements as to succession are not part of public policy. Are not. It's not the public policy clause. It cannot be raised against an agreement as to succession because the regulation has expressly provided for them. So they are not part of the public policy. However, an agreement may be contrary to the public policy for the same reasons, because in concreto may conflict with the value of the person and his dignity. So also this is so the public policy clause can be raised, but the assessment must be made in concrete. Other aspects about public policy regards same-sex marriages. We addressed this problem in the last seminar in Budapest, so we can jump about this. But also this is important because of the other regulation. Because in the regulation 1103 that regards the matrimonial property regime, we have not a definition of marriage. The definition of marriage is left to the single member state, but here in this judgment, the Court of Justice stated that there is a sort of principle of I don't know what they say, the correct expression, the right to move from a state to another state, carrying on with the person the status. So if I'm married in a same-sex marriage in a specific member state that provided for same-sex marriage, it's the fundamental principle of circulation of people leads to the recognition of that marriage also in states that does not provide for the same-sex marriage, and this was affirmed, stated in this case of Court of Justice. Because of the Article 21, there is an anti-discrimination clause. So a person that is married in a specific member state can move and reside in another member state, even if that member state does not recognize same-sex marriages. I have already addressed the relationship with the public policy and Sharia laws, and I said that we have to do an analysis of the material case. We have the possible inheritance and discrimination depending on sex or religion, but we have to do an analysis in concreto. And it is a very important case, not issued by the decision is not issued by the European Court of Justice, but the European Court of Human Rights in the famous case, leading case, Molla Sali versus Greece of 2018. In this case, the difference in treatment suffered by Ms. Molla Sali as the beneficiary of a will drawn up under the civil code by a Greek testator of Muslim faith, as compared with a beneficiary of a will drawn up under the civil code by a Greek testator, not of Muslim faith, had not been objectively and reasonably justified. So, in this case, the European Court of Human Rights recognized the violation of Article 14, prohibition of discrimination. This is a very important judgment because, for example, an Italian notary may draft a will by a testator of Muslim faith, applying the civil code. The civil code, the Italian law, because, for example, that person is a habitual resident in Italy, and give everything to a person that is of not Muslim faith. In this case, the others of Muslim faith cannot challenge that will because otherwise it would be a violation of Article 14. I finished my presentation, and I'll give the word to Charlotte, of course.
Thank you very much to Daniele, and the floor to Charlotte. Thank you.
Yes, good afternoon, everybody. So I have some slides as well to be shown to the participants. I can't see those slides at the moment, but they'll be coming up shortly. So good afternoon, everybody, and all the notaries and judges and participants in Bulgaria and in Italy, and perhaps also in Hungary. It's a pleasure to be here via seminar, and again, I'm sorry not to be with you today in Sofia, which we're very looking forward to coming, but I hope that that's going to be a possibility in the future. So, it's a pleasure for me to be able to speak to you all again. We were in Plovdiv in October last year. I wanted to explain a little bit about who I am and my role here. And of course, in relation to anything that any of my presentation regarding legal English or the English law, I'm very happy to answer questions to any of you individually afterwards as well, and provide my details. I was involved in this course from the beginning with Daniele and Elena. I was invited to particularly focus on the English language aspect of the course. I'm an English qualified solicitor, so I'm a legal practitioner qualified in England and Wales. And I've also been practicing as a lawyer, as a dual qualified lawyer in Italy since 2001. So I'm recognised as both practicing Avvocato in Italy. I'm sorry, the slides that are being shown now are not which we developed over the past 2 years of the course, which is a list of many of the terms and vocabulary used in the regulations in the English language, and also with an explanation with some synonyms as well. There are also slides which I'd ask the technical support to put up now, which are the slides of my presentation. which is entitled Legal English in Practice. So I practice as an avvocato and a solicitor now in my own firm in Rome, in Italy, and most of my work is cross-border legal work in the areas of succession law, family law, and property law. So the introduction of these regulations that we're studying as part of this course have been developments in European law that I've been following for 15 years since I've been in Italy, in particularly the succession regulation up to its introduction in 2012 was something that I followed from about 2005 when a green paper first developed the idea of harmonizing succession law in Europe. I was very disappointed, of course, that the United Kingdom didn't opt in to this regulation when it came into force because, well, as we've seen, as Daniele has already explained in a lot of detail, the English law rules on succession are very different. And apart from the fact that my English clients can now make a choice of law, a choice of English law, there is still great confusion between, in dealing with the estate of a person who dies, a British citizen who dies, leaving assets in the UK and in another country. So I was able to practice in Italy because of the European Union Establishment of Lawyers Directive of 1998. And I was to become and then an integrated lawyer in 2005. So I'm now known as an Avvocato Integrato with full practicing rights in the Italian courts. Could you please go on to the next slide? Just wanted to mention, as I have to in every course that I present or every seminar that I'm involved in at the moment, apologise for Brexit and apologise that we're no longer part of the European Union. Although as of this year, and I always try and explain where we are right now, we're still in a limbo situation, whereas as of the 30th of January, we're no longer part of the EU, but as up to the end of December 2020, all EU law still applies. That's very important for my practice in terms of family law, in terms of jurisdiction for divorce of a British citizen in Italy, or enforcing a maintenance order for a British citizen in another country as well. In terms of the succession law, it has no particular difference, but at the moment, all EU law to which, or regulations to which the United Kingdom is still a member, still apply. Okay, so the next slide, please. So my role in this course, and you've already seen the glossary, and I think the glossary will be available, or will be available to all participants, perhaps to refer to during the course, and it might become more important tomorrow when we hold workshops and we're discussing particular language and case studies. But also, as part of my presentation, I wanted to explain a little bit about the history of legal English language, to understand some of the terms of the regulations itself, to enable you, by listening to my discussion of the case studies, to follow a conversation about these rules in fluent English. This would also help you in the future discussing your own cross-border practice and perhaps a case with a notary or a judge in a different country that you may need to even study and write an opinion on in English. And also at the same time discuss particular differences between our legal systems. And could you give me the next slide, please? Remember, when I might be talking about the United Kingdom and I might be talking about English law, and for any of you that aren't clear on that distinction, remember that the United Kingdom is separated into 3 legal systems. So we have the system of England and Wales, of which I'm a qualified lawyer. The system of Scotland is different. That has its court structure. So I will be, when I mention English, I'll be referring to the Scottish law system. Okay, so let's go back to my explanation of the development of the legal English language, which it's very interesting to look back 2,000 years in terms of, well, looking at the regulations that we're studying and understanding where some of this language has come from. It developed back 2,000 years ago, before the Romans came into Britain, from the Celtic language. The Romans then in 55 BC brought in Roman law and Latin. Then the Anglo-Saxon language overtook, which with its Germanic origins. And finally in 1066, with the invasion by the Normans, the use of French was introduced into the legal system. The legal system started really to develop at the moment of the Norman invasion. Next slide, please. So the common law actually developed from the moment that the king's courts took over from the original feudal courts. And the King of England sent out legal professionals called justices around the country to start to settle disputes that originally would have been settled by the feudal owners of property in the local areas. We can see that at that time there was a mixture of language from English and Latin and French, which, as property disputes in particular were being settled or being discussed, it was found that the common people of England weren't able to follow proceedings because they were in French. So in 1362, we have an original legislation which imposed language on court proceedings. And this, on this slide, you'll see that the statute itself, this legislation, was written in the French language and finally decreed that all legal proceedings should be spoken in English, but then would be recorded in Latin. So we still had the mix of the three different languages, but English language of the courts remained the case up till about 1730, when we see the Proceedings in the Courts of Justice Act. So the next slide, please. Now, the common law really means a common law, one single law, which was developed taking over from the feudal system of law. It was developed by the justices in different parts of the country trying to adopt new similar rules. The common law itself was developed with a system of writs. So if a person in one part of the country had a complaint, they would issue a writ, it would be taken back to the king and dealt with by the king's courts. The main feature of the common law, with which you'll all be most familiar, is that it lacks any single code, unlike Italian law and many systems on the continent. The common law instead is a combination of cases, case law, pronounced by the highest court. In the UK, the highest court is now the Supreme Court, which was formerly known as the House of Lords. So together with the judgments, our set of law is also combined with legislation or statute, where a particular issue in a judgment needs to be clarified and set in stone. So our common law is a combination of judgments and legislation. Legislation could be known as statute or an act of parliament. And I wanted to mention at this stage, over the past couple of years, I've corrected some lawyers about this, the use of this word act. The Act of Parliament is the word act that we use to refer to our legislation. However, in legal English, in civil law countries, I've noticed that many people use the word act to refer to a legal document, a public document, the document of a notary, whereas the correct term to use in that case, I would say, would be deed and not act. Going on to second important principle of common law is that our law is developed through the precedent which is binding. So the binding precedent is also known as the principle of stare decisis, the Latin term which means let a decision stand. So essentially this means that the lower courts are now bound to follow decisions of the high courts of the same jurisdiction, unless those facts are particularly different. And in the case that they're different, a judge will say, this case should be distinguished from a previous case. So that is English law. The decisions of the courts themselves make the law, which is different from the legal systems of civil law countries where there is a written code and the fixed written rules are there to be interpreted by the courts. As we'll see, the many English-speaking nations, Elena previously referred to the United States and how equity there hasn't translated to the United States for different reasons. But most English-speaking nations have inherited the system of common law and most of the principles. And as cross-border legal practitioners in your work, particularly dealing with family law or succession law, you are likely to come across this legal system in the work that you do. If you're dealing with a person that's resident in a system which has a common law system, or perhaps they have assets there. Next slide, please. So I wanted to also give you a brief introduction to the court structure in England and Wales. In particular, in relation to the regulations, we'll be talking about the civil courts. You'll see here under the heading lower courts, we have the criminal courts, which are the magistrates or the Crown Court. But the civil courts will be the county court, which will be lower level, lower value claims, and the High Court of Justice, where in succession work and proving a will, which is known as probate, proceedings will be in the High Court of Justice, which is divided into three sections: the Chancery Division, the Queen's Bench Division, or the Family Division. The higher court then is the Court of Appeal, and the highest court is now called the Supreme Court and previously the House of Lords. Next slide, please. The legal terminology, as I referred to before, in common law has evolved over hundreds of years. And let's say from about the Middle Ages, so let's say the 15th, 16th century, we can see terms that are still used today in legal documents. As Eleanor also pointed out, in legal English now, legal English may be particular legal English which is used for international contract law, or legal English may be the type of English that's used in the European regulations, which is actually very, very standardized law. Legal English that I will talk a little bit about today is a legal English we still see in legal texts, such as a will. So let's have a look at the words that I've highlighted on this slide here. You'll see some of the words that we see in a will or even in the regulation are very early words used in legal English which derive from French or Latin, such as estate, executor, property, lease, or tenant. In Middle English, from about the 16th century, we see the use of very complex words which are still found in legal texts today, such as notwithstanding or aforesaid. Now, these words, if you break them down, are actually words which are made up of different pronouns and verbs, which, if you think about what I said earlier about the binding precedent and the need to distinguish one case from another, or to impose a principle made in one case that is then going to carry on for hundreds of years and being the binding principle of a concept, it was so important to be very, very precise in how texts were drafted. So that's, there you see the introduction of Middle English words. And another way in which the meaning was set in stone and repeated to make sure and to emphasize for the future interpretation of that word, we see doublets and triplets. So you see phrases today, of which last will and testament is an excellent example, in which all the different languages that have gone into English, the Germanic language, the French and the Latin languages, have been put together in one phrase. So last will and testament is actually Anglo-Saxon English together with French. Terms and conditions, cease and desist, goods and chattels, and many others, and even a triplet here to give, devise and bequeath, which is a common term that you will frequently see in a standard English will, even made today, where give, devise and bequeath, each word from a different element of the English language, practically means the same thing, although now in the different languages themselves, if you analyze the word, they may have slight differences. But I think with using the three words together, it emphasizes the word to give another person. So I hope that this history into the common law has been useful background. And I'm pleased to say that now in 21st century legal English and the English that I use in my work today, this very complex language has been broken down. There's now the use of plain English, which has overtaken legalese, which could be English, which would have been impossible for most people to interpret. And now also a very neutral language has emerged, which is the language of the text that we'll be studying in this seminar. Next slide, please. I'd also like to give you a very brief introduction to the principle of equity, which is Elena also referred to in her presentation. And equity is a part of common law. Equity once was separate from common law in that it was a separate system of courts. But the principle of equity, which means justice or fairness, evolved from common law. And why is that? Because originally in the common law courts, so we could be talking then about the 12th or the 13th century, the King's Court was making decisions on disputes, for example, on a property dispute. But the only remedy that had been developed at that time was damages, to give a person compensation for the loss that they'd suffered. But petitions were made to the king saying, well, even though the remedy of damages has been given, this doesn't overcome the problem that I've got. So the court then developed, the king appointed a chancellor to add a remedy which might make that decision more fair or more just to the person that had been wronged. And the Chancellor set up the Court of Chancery, which is a separate system. And the Court of Chancery was established to find judicial remedies based on these equitable principles. So once the courts had reached a decision that a law had been violated, or for example, a contract had been breached, the principles of equity would be referred to and a new remedy found. Nowadays, the courts, there is not a separate Court of Chancery. We saw earlier in the structure of the English courts that the Chancery division is part of the High Court of Justice. But the principles of equity are still present in a modern day case, in a civil law case, and equitable remedies are still remedies that are requested today. For example, as you'll see in the next slide, please, one remedy could be an injunction. An injunction is a prohibitive order which stops a party from repeating an action that has been found to violate a law, such as forbidding a person to come within a certain distance of another person is an example of an injunction. And another example of an equitable remedy would be a specific performance. Now, that is the remedy that we request where it's been found that a contract has been breached, but the judge needs to make an order saying that piece of work or that action that was requested, required to be carried out by the contract should still be performed. Now, equity is also the principle by which the trust, the law of trust, was developed. Could we go on to the next slide, please? The trust is an element of common law, which was developed in the courts of chancery, but mainly beginning in the area of property as an equitable remedy. And the trust that you may come across in your practice or in your study of English law, or even in your country in a principle or document or a concept that's been established in your own internal law, a trust may be an inter vivos trust, which would be a legal deed set up during a person's lifetime or on death. The definition of those two types of trust is contained in the Hague Convention, which is the Convention on the Law Applicable to Trusts and Their Recognition of 1985. Now, I'm aware that Bulgaria is not a party to that convention, or Hungary. Italy is. Therefore, Italy recognizes directly a trust as an instrument, even though in Italian internal law, the trust can only be recognized insofar as it's clear this is a foreign law instrument. So the trust was an addition to the law of property as it developed through common law. And for example, I want to explain and break down exactly the meaning of this, the meaning which is common throughout the principle of an inter vivos trust or a trust on death, is that the principle is that a person that owns property transfers that property for another person who is the trustee to hold for the benefit of a third party who will be the beneficiary. If we could go on to the next slide, please. The concept of a trust recognizes that there's a split between the legal ownership, between the title and the eventual beneficiary. Here, this slide refers to an inter vivos trust. So the trust deed is the document by which a person in their lifetime, who is known as the settlor, transfers ownership of their property or assets to the trustee, who could also be themselves. But by that trust deed, they bind themselves to hold that property for the benefit of another. And the trust deed itself will set out the definition of what the property is, how long the trust can last for, what the trustee's roles and duties are, what the beneficiary may be able to ask for. And in that way, many different types of trusts have evolved, which might be discretionary trusts, for example, in terms of a lifetime trust. On the other hand, the concept of a trust can also be seen the testamentary trust can be formed at the moment of death, either by the terms written into a person's will, but at the same time, a statutory trust is also formed on death under English law. Now again, let's go back to break down what the concept of that trust means. In this slide, you can see the terminology that's applied to a testamentary trust. In a last will and testament, the testator, the person who's writing their wishes for what will happen to their property or their assets on death, will name in that will an executor and trustee. And normally those words are interchangeable in an English will. So I leave my property to my executor and trustee, who will hold that property for the benefit of the heirs, who are the final beneficiaries. If there is no will, then a statutory trust will arise on death. And why is this? This is another concept that's important to distinguish between how common law treats property on death and civil law systems. In a civil law system such as Italian law, for example, at the moment of death, the heirs who will be specified by the civil code in terms of who will be the family members entitled to benefit from all the property and in what shares. At the moment of death, all those beneficiaries will immediately take on all the rights and liabilities of that property that's being passed to them. Very differently from this, in common law, at the moment of death, there is sort of a limbo land, a limbo until a personal representative is appointed by the probate court. That means that a statutory trust arises if there is no will, because the administrator of the estate will then take on a role of trustee and administer all the benefit, all the assets for the eventual beneficiaries. So this is an example of a statutory trust arising where there is no will, whereby an administrator will manage the property for the final beneficiaries until they are assigned the property or the property is distributed to them. Can we go on to the next slide, please? This is an example of a testamentary trust written into a will. I give, devise and bequeath all of my real and personal property whatsoever and wheresoever situated, not hereby or by any codicil hereto, otherwise specifically disposed of, including any property over which I may have a general power of appointment or disposition by will, to my trustees upon trust, to sell, call in and convert the same into money, but with full discretion, shall think fit, but with full power to postpone the sale, calling in and conversion thereof, for as long as they in their absolute discretion shall think fit, and to discharge therefrom my just debts and my funeral expenses, and to stand possessed of the remainder, hereinafter called my residuary estate, upon and subject to the following provisions of this my will. Now, this may seem that we're reading a will from the 17th century, but the language may be still Middle English with doublets and triplets, as I described earlier, but this type of clause is still commonly found in an English will today. Next slide, please. So having given you a little bit of an introduction to equity and trusts, I should stress again that trusts are expressly excluded from the scope of the succession regulation by Article 1 to J, in that the creation, administration and dissolution of trusts are excluded from the scope of the regulation. However, it should be noted that in recital 13, this is not a general exclusion of trusts. So in the succession regulation, where you may be a legal practitioner in Bulgaria that's dealing with an English will of a British national who has deceased in Bulgaria, who has left a testamentary trust in their will, appointing trustees that might be resident in the UK, that may have the power or have been asked specifically to deal with gifts to children or income to be paid to children up to a certain age, even after they're minors. Can that trust be interpreted in Bulgarian law? It may need to be, if English law still applies to that person's succession. So I hope that the examples I've given you give some insight into your understanding where a trust, either inter vivus or testamentary, might apply in your practice. Next slide, please. In every jurisdiction, there are different rules for the drafting of a last will and testament, which a testator will need to follow. In the case of an English will, the formality of this will is decided by a statute, which is the Wills Act of 1837. The formality, the formal validity of a will is the form in which it's written. So in English law, a will is written in any form. It could be handwritten, it could be typed, but the principal requirements of a will are that it's signed and dated in the presence of two witnesses who have witnessed the testator actually signing the will. So this is the formal validity. The actual form of a will, in terms of the sequence that it takes of its clauses, can be written in any way. It's very common for clauses in an English will to be numbered, to follow paragraphs which deal with, on this slide, you'll see the various topics that a testator will need to address in the will. And if they don't address it, then the Wills Act will interpret for them. But the person will normally make a declaration about their capacity to make a will, that they are of sound mind at the time. It will deal with the revocation of any previous wills. Now it may also deal with a choice of law. As we'll see later, it's not a requirement of English law. It's not even recognized that an English testator may make a choice of law, for reason of the scission principle that we'll see later on, that Daniele has also referred you to. However, in drafting English wills, for clients now that have assets in more than one country, it's common to see a choice of law, even if that is just to set in stone a choice that English law should govern a person's worldwide assets. And as we know from the succession regulation, that choice of law can also avoid the operation of renvoi or rinvio to another country's law. Other clauses that an English testator may want to include in their will could be intended marriage. Now, if a person is intending to get married, it's very important that this is put into a will, because in the absence of that, the will, the later marriage will actually revoke a person's will. It could, unbeknown to them possibly. However, if they've included in their will that they intend to marry and they intend that any later will is not revoked by marriage, this clause needs to be inserted. It's also very common for English testators to nominate the executor or trustee, because as we know, there is a statutory trust. The executors will be the people that will be the legal owners of all the person's property and assets until the estate has finally been administered and the property is distributed to the eventual heirs or beneficiaries. And other clauses that will be commonly included in English will are legacies, funeral directions, the residue, and at the end, the witnesses will state their name and address, often their occupation. Quite often that the will is signed in a solicitor's office. The witnesses will actually be the staff of the law firm. So could we go to the next slide, please? This slide is entitled probate. So probate, which comes from the French word to prove, is the procedure by which the civil courts of England and Wales, which is the family division, which will be separated up into the probate registry of the local areas of England and Wales, the probate division will, the probate registry, will authorise a personal representative, a PR, who will administer the estate of the deceased, who will then hold the property of the deceased on trust until it's ready to be distributed. In the case where the deceased left a will, this will be a grant of probate, and the personal representative will be the executor. Where, on the other hand, the deceased died without making a will, it won't be a grant of probate, although it will have a similar effect. Although there is no will to be proved, there will be a grant of administration, which will name the person who will be the personal representative, or otherwise the administrator. Next slide, please. In the case of a grant of probate, then the will is attached to the grant of probate. This is an example of a grant. In the High Court of Justice, the District Probate Registry at Winchester, names that I've deleted the names here, the name of the deceased, the residence at the time of their death, the date of death, where they were domiciled, and then later on it says that the last will and testament has been proved and registered, and that all the administration of that estate, which by law devolves and vests in the personal representative of the deceased. That means the property is now considered on a statutory trust to be the legal ownership of the personal representative. And then later on in that grant of probate, that person is nominated, and that gives them the legal title to dispose of that property, to sell it, to alienate it, to deal with it, to liquidate the estate. Next slide, please. I want to now explore as an example of what you as legal practitioners in Bulgaria may need to deal with if you are facing an English will of a testator that you need to prove or publish in Bulgaria, or determine whether it's valid formally, whether the substance is valid, whether the terms, perhaps in your country you might want to decide whether the terms are contrary to public policy, or otherwise to liquidate the estate and transfer the property of the deceased to the beneficiaries. So you're faced with a valid English will. Now, under the succession regulation, Article 27, even though the English will and the UK is not a party to the regulation, you are faced with a will of any third state, of any other common law country in Bulgaria. You will look at Article 27 of the succession regulation, and you will consider the formal validity of this as a disposition of property upon death made in writing. So under 5 possible categories in Article 1 here, you can decide whether or not this will can be considered formally valid. Was it valid according to the state in which the disposition was made? So was it executed in the UK? In which case, if it was a will signed in front of 2 witnesses, it would be valid. Was it valid in terms of the law of a state whose nationality the testator possessed, or of a state in which the testator had his domicile? I've just seen flashing up a question about domicile, and I will be coming on to that in a moment. Was it valid in terms of the state in which the testator had his habitual residence? Or was it valid in terms of the state where the immovable property is located? So on many, many levels, it's very likely that an English will is going to be valid as long as it's valid in terms of one of those items A to C of Article 27.1. You will then be going on to decide which law is going to apply to the person's estate, and whether therefore this will is substantially valid. Did the testator leave all their property to one of their 5 children? In which case you will be looking at, it's very important to know which law is going to apply to the succession. It does pose a conundrum. The applicable law, as we know, if the succession regulation applies, therefore is the death before or after August 2017? If it was after, will it be determined by the habitual residence of the deceased, or will the applicable law be determined by the choice of law that a person has made in their will? If, in a case of a British national who died resident in the UK, it's likely then that English law will apply because the habitual residence will apply. So you will then ask, what does English law say about the substantive law of succession? In English law then, we're going to need to look at the rules of private international law of the UK. What do they say about a succession depending on where the property is based. We're going to go on to examine that in a moment as well. Quite different from the principles of civil law systems. As we've already discussed, English law has no written code, there are no statutory heirs, there is no particular fixed share of any estate which has to be passed to a family member. Could we go on to the next slide, please? There is a founding principle of English succession law, and that is the principle of testamentary freedom. This is a big part of my practice, and where many English-speaking residents in the UK, or British nationals or nationals of other common law countries, where the principle of testamentary freedom is prevails, and again, it's a very important part of our culture. Why is it such an important part of our culture, and has been for maybe 200 or 300 years, from the time where the important political climate at the time was liberal philosophy, the concept of individual freedom as against the control by the state. And for example, here in this slide, you can see a quote from the leading political thinker of the time in 1848, John Stuart Mill, in his Principles of Political Economy. This is really the concept of testamentary freedom. As he said, the ownership of a thing cannot be looked on as complete without the power of bestowing it in life or death at the owner's pleasure. So it's recognized that a British national may make a will and leave their entire property to charity, or their entire property to somebody that's not related to them, whereas their spouse and 5 children have no fixed right in law to a percentage share of that estate, which they do in Italian law and in many of the civil law legal systems on the continent. However, this right of complete freedom is tempered by a very important law, which is, well, since only 1975, the Inheritance Provision for Family and Dependents Act 1975. Earlier, Daniele talked about how the Roman law concept was that the principle of who should benefit from an estate was sort of really left in terms of discretion to the need of the person. In a way, the Inheritance Act of 1975 recognizes this principle of Roman law. There is the discretion of the English courts to listen to the claim of any disgruntled heir who might make a claim saying, my father left me nothing. My father, who was a millionaire, left everything to charity and excluded me. We haven't spoken for the last 10 years. He decided to exclude me from his will. Can I make a claim? Well, yes, he can make a claim if his father, if the deceased was considered domiciled in England and Wales at the time of death. He can make a claim to the English courts. However, the English courts will then use full discretion, and they will look at the needs, they will look at all the circumstances, they will look at the relationship, they will look at the needs, the financial, the fact of the person claiming being a dependent. It can be a family member with a small need, but the courts will, and there's a lot of recent case law on this point of what exactly is a dependent and what is the person's need. And the court will decide whether or not that person can have a claim of an estate, and there is no fixed share, there's no percentage, but in all the circumstances, a court will make an award if they feel that there is a just cause for a claim here. So could we go to the next slide, please? Now, Daniele had talked about the principle of scission and the principle of private international law of England and Wales. Again, we have no written private international law, unlike Italy. This is why in an English will, there is not generally a choice of law made, because English law doesn't recognize that. English law splits at the moment of death the assets of the deceased into 2 sections: a movable property, bank accounts, investments, shares, or immovable property, real estate, buildings, land. And in terms of movable property, the law that applies, the law that determines what succession law will apply to a person's bank accounts, for example, which may be more than one in different countries, these will all follow the succession law of the person's domicile. Whereas immovable property will follow the succession law of the country where the immovables are situated. So the Latin term, lex recitae. Could we go to the next slide, please? And coming on to, I know this question has been asked, the domicile is a principle which is very, very important in English succession law. It's also very important in English taxation law, particularly for inheritance tax, when, as you may be aware, the inheritance tax threshold is £325,000, and anything over that amount is taxed at 40%, so very, very heavy taxation. Now, that will only apply to a person's worldwide estate if they are considered domiciled in England and Wales. Now, the tax authorities have their own determination of what domicile means, so let's leave that aside for one moment. What I want to explain today is just the domicile principle of English law, which applies to succession law. A British national is born domiciled in England and Wales if that is the domicile of that person's father, if their parents are married, or their mother if that person is not married. So that's your domicile of origin. But from the age of 16, it is possible to then acquire a new domicile of choice. The courts may need to determine after a person's death what their domicile was. In the same way as a case which involves the succession regulation, the courts may need to determine what was the habitual residence at the time of death. So specifically with domicile, specifically relating to a British national with a connection with England and Wales, their domicile could have changed after the age of 16. Generally, this means, and I always think that domicile is far closer to citizenship or nationality than to the concept of habitual residence. The domicile will be the place in which a person has moved to a different country, taken up residence, but on a permanent basis. In order to prove domicile, there must be some intention to live permanently in that country. Again, if you look at the English law decisions in the Supreme Court and the House of Lords on domicile, there will always be, where there's some doubt, there'll always be an element of permanency. If the person had gone for work, but had left family behind in the UK, had made arrangements that they were going to be buried ultimately in the UK, and made no other statement about a change of domicile, it's very likely that they would still be considered British domiciled. It's not easy to give up. In a case where there's a doubt, and I do advise British clients even to make an affidavit or a statement about their domicile, or they may even want to write it in a will. Somebody that has been living 20 years in Italy, that came here for work, but eventually married a national of this country, or even settled down, had children here, and has an intention to remain permanently here, they would be considered to be domiciled now in Italy. So I hope that answers some of your questions on domicile, but we may want to come back to it tomorrow when we look at some of the case studies. And I think that's my final slide. Yes, I wanted to, I don't know if I have much time left on my presentation, but there's a very interesting case which feeds back into some of the points I've raised today in this presentation. It's a case in Italy now, decided only in January in the Italian Court of Cassazione, but in fact it's not a final case because even though it's at the Cassazione, it decided the case of a British national and his will in relation to his second wife, who was Italian, and he had property in Italy. the Supreme Court in Italy have made a ruling giving their opinion on some of the facts, but they have referred it up to the Sezioni Uniti, the united sections of the Court of Cassazione, where once that's decided, it will also become a form of binding precedent in Italy. This case, so this is one of the many cases that's evolving as we're doing this 2-year training project. We'll see, hopefully, well, perhaps in a year or so, we might see the result of this. The fact of this case, very briefly, before I finish my presentation, it relates to Peter, who was a British citizen who was domiciled in the UK at the time of his death, and his second wife, Benedetta, who's an Italian citizen. Now, he made a will in which he only left €50,000 to Benedetta. This was before they were married. And the rest would be divided, and the rest, quite a substantial estate of several million euro and properties in Italy, would have been divided between his 7 children from his first marriage. But he married Benedetta several months after his will was made in 1997. And by English law, as I explained earlier, English law considers marriage to revoke the will. So if that will was revoked and Peter's substantial Italian property was going to be dealt with under Italian law by the Lex Re Cito rule, because his immovable property is in Italy, this means that the civil code steps in, and as at the time of his death, he's married to Benedetta, she will, by law, take 1/3 of the property, and the 7 children will share in the remaining 2/3 of the property. So he'll be considered by Italian law to have died intestate. And the next slide, please. So as I said, this is a very, very detailed judgment which deals with many different aspects of English law, English succession law in Italy, including examining the rule of scission, how it affects movable and immovable property, whether scission was contrary to Italian public policy rule, but in particular the rule on revocation. And the interesting question here is, was revocation of the will a matter of family law, or is it a matter of succession law? If it's family law, then this is going to be decided at the point of the marriage, that all the wills ever made by this testator would be automatically revoked by English law. However, if it was succession law, then if Italian law is regulating the property, which is situated in Italy, Italian law of succession would not consider that will revoked. So Daniele and I have discussed this case, and we've examined English private international law and the rule on revocation by marriage, and the doctrine by the leading theorists on private international law and English law would tend to suggest that this is a matter of family law. So we feel quite confident in this case that the will have been revoked by the marriage, so that Benedetta will be able to claim her 1/3 share. So coming to an end now of my presentation of today, and tomorrow I'll be with Daniele dealing with the workshops in the afternoon. Again, I just wanted to say that I hope that I've given you some very elementary insights into some of the key concepts of English law that you may face in your practice as succession and family lawyers or judges in Bulgaria. And also to make just one comment also about the value of this training program. This is not just a one-off seminar that we're presenting with some difficulties, and I apologize for my difficulties at the beginning over video for the first time. But also this is a 2-year project, which, as all the trainers and all the participants have developed their skills over this time, we've researched together, we've discussed together, we've analysed these regulations. Every seminar that we've given, I think, has built up a little bit on what we're discussing. And I think the project is also, it's not just seminars, it's also, there's a lot of material that we've put together. We've registered video lessons, we're writing a handbook. There's a lot of material, case studies that I think are invaluable to people. And I don't think it's going to end here. I think this project also will be very useful for years to come. And I hope that everybody that's participated today in the future will check back in and continue to follow us. I think we've built up a very, very valuable body of expertise. And well, thank you for everybody involved, and thank you for your attention today. I hope you've enjoyed that and it's been useful. Thank you.
Very much, Charlotte. There are some questions on the webinar chat. And well, I think that about the concept of domicile, Charlotte has answered with a slide. Then always for Charlotte, there is a question about a good law dictionary that can be useful for us, an easy explanation of EU law in manner as she does. So, Charlotte, can you suggest a good dictionary of EU law?
Oh, back on video again. People
A
can
dictionary,
see.
a dictionary. A dictionary.
Well, by a dictionary, generally you mean a translation from one language into another. Here, how we're presenting this seminar is more than translating words. I can't translate anything into Bulgarian, I'm afraid. But I think the start of this project was the glossary. I'd like to think about this overnight, and perhaps I can answer that question tomorrow. I don't personally have any material that I use, because this is, again, this is so specialized, this area. This is probably quite a unique training program that we're explaining all these concepts of European law in one language that need to be interpreted by practitioners in different countries. So perhaps that's a gap in the market. I will have a think about it overnight and see if there's anything that I can suggest you towards. I hope that's helpful.
You can think about some dictionaries, and we can explain in our in our website, perhaps in the future. I want to say to Kalin that on our website there is a dictionary now about some important words. So please go to our website. Then there is a question about the situation, the principle of application of the law of recite from immovables. If this recite suffers or doesn't suffer exceptions. Daniele, can you answer this problem?
The question comes from our colleague, Ugo Friedman.
Yes.
I think he wants to know if the rule, the principle of scission suffer exceptions. So if it is possible that English law is applicable also to immovable outside United Kingdom. This is a very important question, because if we read the Article 34 of the regulation, we can see that the renvoi is not applicable when a person makes a choice of law. So from an English point of view, and also Italian, I think, if we accept that also a British national can make a choice of law, even if United Kingdom is not member state, so it's not bound by the regulation. We have to accept that English law will apply to the whole succession, so also to the immovable located in Italy. This is very important, because if we accept this conclusion, there are no the disposition of the forced heirship provision provided for by Italian law will not be applicable. This is the view of the English professional. The problem here is that it's not a solid conclusion because we are in a situation where we are applying to Italian immovables a law that doesn't want to be applied. This is a very important question, and at the moment I know that the solution is that English law is applicable to all immovables, so also the movable outside in England, but from our point of view. We are not sure that from the United Kingdom point of view, it's the same rule. So there is maybe also a conflict of law, because English courts may state that English succession law is not applicable. Italian courts may accept that Italian law is not applicable, but English law. This may be a conflict of judgments. So we have to see practical cases and see what's the solution. I don't know what Charlotte think. I know that in my professional activity appears that English professionals I'm quite sure that a British national can make a choice of law and lead to the application of English law to all immovables, also in Italy. What Charlotte think about this? It's a very
I think it's very difficult to explain this principle in general terms. I mean, I think as a practitioner, you tend to take a set of facts first and break down the legal principles and apply them to the facts of the case. Who is the executor? Who are the heirs? Where are they situated? What is the property? Every case will be different. When we say, so the law of lex recite, so let's talk about Italian property being dealt with in an estate of a British national. The substantive law of succession is normally what is the most in dispute. Who are the heirs? Are the heirs the heirs set out in the Italian Civil Code? Or are the heirs, can the heirs be those named in the will? You separate the substantive issues from the administration issues. There will also be issues of how the transfer of property should be registered in the Italian land registry, for example. You may have an English will that names an executor and trustee who is given powers to immediately sell the property before transferring to the final beneficiaries, which is in direct contrast to Italian law, which will expect all the final beneficiaries to already be the owners of the property as of the moment of death. So not allow those, the beneficiaries to immediately sell the property. But I have dealt with, let me give you an example. Actually, it's of the grant of probate that I showed you earlier as a document, that a British national, originally of Italian nationality, died in the UK, leaving a will in which he named his sister as the executor and trustee on behalf of his minor children who lived in Sweden. His only property was a house in Italy. To make this even more complicated, he also owned the house in Italy in a completely different name. Nobody knows why, but we also had to prove that he was the same person as the man that made the will. In terms of the private international law and scission, lex recite applied. His heirs are his two minor children, so there was no contest about who the heirs should be. But the Italian notary accepted that the sister, who's the executing trustee under the English will, had the power to own the property on trust as an executor. So this property was registered in the Italian land registry as owned by the executor and trustee, then sold by the person who had the power of attorney, and the proceeds of sale distributed to the minor children in Sweden. So that is a very practical example of lex recite. Luckily, in this case, there wasn't an issue of dispute about who the heirs would be. For example, if there'd been an illegitimate child that had popped up and claimed a part of the estate, then we would really have been in trouble. But in terms of the administration of the property, the terms of the English will were recognized here in Italy. And as often you will see, a pragmatic solution has to be found to ultimately reach the aims, the testator's aims and wishes in their will, which was ultimately carried out in this case. I hope that answers your question.
Okay. See you tomorrow, because I don't see any other question. No. Okay,
No.
See you tomorrow.
Bye. See you tomorrow at 10.
Bye, thank you, bye-bye.